We are now on the second part of the lesson on the judges and the social media. And to give you a summary of this part of the lesson, I will be talking about two cases decided by courts in the Philippines and in the United States of America that involve judges and the social media. And also, we will be exploring the guidelines set by the UK judiciary when it comes to judges and the social media, since I could not find any case decided by any of the EU courts, so as to have a proper distribution of sources of authorities. Now we start with the Philippines. This case is known as the Lorenzana versus Austria case, and if you can look at the source or the details of the decision made by the Supreme Court. And in this case, actually, the judge has or had two complaints against her. One is Judge Austria was facing a main complaint on a related to a case pending before her sala, and also a supplemental complaint. And we will be discussing more of the supplemental complaints. And the complainant alleged that Judge Austria displayed her photographs in Friendster, and if those who could relate to Friendster, actually, when I think I was in high school when Friendster was out and being used, and in the said Friendster account of Judge Austria, her personal details as an RTC judge was available, and she allegedly did that for purposes of finding a compatible partner, and also she posed her upper body barely covered. I'm quoting actually from the Supreme Court decision, covered by a shawl, allegedly suggesting that nothing was worn underneath except probably for a brassiere. And the Supreme Court continued by stating the respondent's defense. The photos, according to Judge Austria, could hardly be considered vulgar or lewd, and off-shouldered attire is an acceptable social outfit in the contemporary standards and is not forbidden. And the respondent also said that there is no prohibition against attractive ladies being judges. Actually, when you go to court, you can really find very attractive judges. And my first appearance as a legal practitioner was before a lady judge, and I'm amazed of her beauty. I will not just mention her name. Okay. To continue, the Supreme Court said, yes, judges are not prohibited from becoming members of and taking part in social networking activities. Could be Friendster, Facebook, especially now. The Facebook is very commonly used in the Philippines, and also in Instagram. Now, the court is reminding that the judges should not thereby shed off their status as judge. So even on and off the bench, they should be maintaining their status as the manifestation of justice. They are the personification of justice and the other virtues related to the justice system. Now, the Supreme Court also said that the new Code of Judicial Conduct does not prohibit actually from joining a judge from joining or maintaining an account in a social networking site. And joining is considered as a freedom of expression. But you have to remember that this freedom of expression is not absolute, because the Supreme Court further stated that in the exercise of their freedom of expression, they, referring to the judges, should always conduct themselves in a manner that preserves the dignity of the judicial office and the impartiality and independence of the judiciary. Now, the Supreme Court specified that sections 1 and 2 of Canon 4 of the new Code of Judicial Conduct prohibits impropriety and even the appearance of impropriety in all their activities. The judges are being referred to here. Now, based on this provision, the respondent, Judge Austria, disregarded the propriety and appearance of propriety required of her when she posted Friendster photos of herself wearing the off-shoulder attire, and it was available for public viewing. But since Facebook now has a button for like only me who could view, or only you could, the owner of the account could view the photo or even the post. Now, the Supreme Court detailed that when she made the picture available for public consumption, Judge Austria placed herself in a situation where she and the status she holds as a judge may be the object of public criticism and ridicule, especially these days that netizens are very, very critical and they don't hesitate to post comments and even making threats. There could be news on that available online saying that the owner of the account is being threatened. Now, as the visible, this is what I was talking about earlier, as the visible personification of law and justice, however, judges are held to higher standards of conduct and thus must accordingly comport themselves. And this is for those bar reviewers or bar reviewees and those who are taking up law. You should remember this guideline or this case law decided by the Supreme Court, because it might take a long time for the Supreme Court to liberalize this guideline or this rule. Now, what was the penalty on the judge? On Judge Austria? We will focus again to the supplemental complaint. She was admonished to refrain from further acts of impropriety and to refrain from conduct unbecoming of a judge, with stern warning. And it must be noted that this is the first admin case of Judge Austria. Now we go to the United States of America. In this U.S. versus Sierra Pacific Industries Incorporated, and this was decided in 2017 by the Ninth Circuit Court of California. The federal judge who handled the case tweeted a headline saying Sierra Pacific still liable for Moonlight fire damages, and linked to a news article about the ruling he just issued. And this tweet, of course, annoyed the defendants because they're saying that there's no, in the settlement, the settlement expressly denied liability on the part of the defendants. And the also the federal judge, aside from tweeting, um, the judge followed the Twitter account of the U.S. Attorney's Office, and of course, the U.S. Attorney's Office is the adverse party in the case, and the Supreme Court or the Circuit Court said that the single challenge tweet does not amount to public comment on the merits of a pending case. So it was said that there's nothing wrong with that. And the three relevant tweets containing only links to news articles and coming from an account not publicly identifying a member of the judiciary. So the judge who made the tweet could not be identified, and thus it does not create an appearance of bias that would warrant or that would be a reason for recusal, or the judge will inhibit from handling or trying the case. Now, according to Judge Herbert B. Dixon Jr., and actually I got this from the American Bar Organization website, he advised judges four things. Instead, he said there in his column or in his article that instead of making a list of 10, he said that he will just make 4. Now, he said that judges must maintain dignity in every comment, photograph, or other information shared on social networking sites. And they should not make any comment on a social networking site about a pending matter, not to a party, not to a counsel for a party, and not to anyone. And in addition to these two, he said that judges should not view, even viewing is discouraged, a party's or a witness's pages on a social networking site or use social networking sites to obtain information regarding a pending matter, because this is contrary to the fact or the directive that judges should investigate cases independently. Now, recuse from any case where the social networking relationship with an attorney or a party creates bias or prejudice concerning the lawyer or a party. So that's the advice of Judge Herbert B. Dixon Jr. Now we go to the United Kingdom. Although I could not find any case, but the United Kingdom judiciary, there's a guideline for the for the judges, and judges are told to be wary of 10 things or 5 things, sorry. Publishing more personal information than is necessary, like any information that would link to them or to their family. Posting information which could result in a risk to personal safety, and that is like announcing possible holiday plans. Automatic privacy settings. So, judge should be familiar actually with the privacy settings of social networking sites. And judges are reminded or should be worried of the lack of control over data once posted. So once it is available online, you have no control over it. You may say that you deleted it, but someone could have made a screenshot of it, took a picture of it. So posting photographs of themselves in social or casual settings, whether alone or with a family members or friends. So there could be a safety concern here, or a possible like the person is linked to someone who is a friend and also has a case pending before the sala of the judge. And the judiciary of the United Kingdom said in this amended guide to judicial conduct, and it was issued on in March 2020. You can see the source here are provided below this slide. It said that whilst blogging by members of the judiciary is not prohibited, judicial office holders who blog or who post comments on other people's blogs must not identify themselves as members of the judiciary. So there's an implied message here saying that you could do all comments and the posts and even express your sentiments so long as you are not identifiable, or the being a member of the judiciary is not available or made open to the public. And the members of the judiciary must avoid expressing opinions which, were it to become known that they hold judicial office, could damage public confidence in their own impartiality and in the judiciary in general. So, for those who are planning to become judges in the future, you have to be wary, careful of everything, even in your own personal lives. So, I hope this part of the lesson gives you a better picture of how demanding the job or the position is. So, thank you, and I hope you learn and we keep learning. And I just want to announce that the next lesson on judges would be on the non-binding guidelines on the use of social media by judges as issued by the United Nations Office on Drugs and Crime. So I hope you look forward to what the UN said on this matter. Thank you so much and take care.